Disabilities Awareness Month webinar brought to you by the Essex County Surrogates Court. My name is DeVille McDougall. Unfortunately, we're having a little bit of technical difficulty, and our surrogate Alter Reed Kinney is not here. But when he, gets back and finishes correcting his technical difficulty, he will come in and talk to everyone. So I'm going to just, since I don't want dead air, let me just start by saying this is the Essex County Surrogates Court. Our responsibilities include validating wills, appointing administrators for those who die without wills. That's intestacy. We handle anything that relates to intestacy, appointing administrators, and review and assist with the documents surrounding adoptions and adult guardianship. Today, because this is National Developmental Disabilities Awareness Month, we are going to focus on adult guardianship today. So, one of the things this office does, we touch on the lives of almost every individual in Essex County, and we want to ensure that every process we undertake, every form you fill out, every question you ask, you are equipped with accessible, approachable, and accurate information. We're hosting this webinar so that you will be prepared and ready for the adult guardianship process. That is the transitioning from an individual from childhood to adulthood, and that happens in New Jersey when they reach the age of 18. So those children with developmental disabilities, this process is necessary. So Developmental Disability Awareness Month was established to raise awareness about the inclusion of people with developmental disabilities in all facets of community life, as well as awareness of the barriers that people with disabilities still sometimes face in connecting to communities in which they live. Our goal here today is to support parents, potential guardians with the court filing process so the transition can happen smoothly and effectively. Now, normally this is where surrogate Alter Kinney turns this over to me. And so since he's not here, I'll turn it over to myself and introduce. We have two panelists today, and it appears that Miss Thomasina Thornton is also having technical difficulty, just like me. That's why you don't see me, but you hear my voice. So I'm going to wait till Thomasina pops up to introduce her. So what I'm going to do, since April is here, and if I say it wrong, April, correct me. This is April Franduto.
Nice job. Thank you so much. Good evening, everyone. Thank you for joining us, and a special thank you to the Essex County Surrogate for inviting me on the panel. I'm just going to switch over to a slideshow I have prepared. I'm hoping everybody can see this. So most of you are probably here. By the way, let me just go back. I am from the Bergen County Surrogates Court. Every county in the state of New Jersey is charged with handling the adult guardianships for the residents of their county. So we handle all of Bergen County. Most of you are probably here because you have a loved one who's about to turn 18 and you're starting to freak out a little bit. I understand. I'm a parent too. I have a child who's 16 and a couple younger ones than that. And I can't believe in less than 2 years he is going to turn 18 and at that point be able to make life-altering decisions that up until this point my husband and I have made for him. That's crazy considering he was really just a little kid. But since I can't stop time yet, this is really happening, and the same is happening to you. It's very scary as a parent, but let alone for a parent of a loved one with a developmental disability. So what are you supposed to do? First things first, don't panic. Don't get too far ahead of yourself. It's going to be okay. This is where adult guardianship comes in. You need to determine whether or not an adult guardianship is appropriate in your child's instance, or if there's a less restrictive option. Adult guardianship is a last resort. We are taking away somebody's legal rights. So You really don't want to do that unless there are no other options. Some examples of when adult guardianship might be appropriate are if somebody has a developmental disability such as autism or Down syndrome. But if you notice, I said the word might. I said that because everybody is unique. Just because somebody has autism does not automatically mean that they're going to meet the criteria to be adjudicated as incapacitated. For example, let's suppose somebody has a physical disability. They're in a wheelchair. I have this phone call a lot from people, and they think because that person is disabled physically that an adult guardianship is appropriate, but it's not. An adult guardianship is when somebody cannot make decisions for him or herself. Okay, so let's go to who can be declared incapacitated. In New Jersey, you have to be 18 years or older to be declared incapacitated. We cannot have a court date until after the child turns 18. And the criteria, as I said before, is if somebody is unable and unfit to manage himself and his or her own affairs. So who can file for guardianship? I'm sure you're all wondering that. First things first, if we have an 18-year-old, oftentimes it's the parents seeking guardianship. But that's not always only the case. Sometimes we don't have parents and we have aunts or uncles, grandparents, step-parents. We could also do more than one person. So that's called a co-guardianship. And oftentimes we have parents and an older sibling of an alleged incapacitated who all want to be co-guardians. That way, as the parents age, the sibling can then become the sole guardian if the time comes that mom and dad can no longer act as guardian. There's a few different types of guardianships here in New Jersey. First, we've got general versus limited. Just understand that going in as a parent, you cannot make the decision whether or not your child needs a general or a limited guardian. That's reserved for the Superior Court judge who is deciding the case. But so you understand, a general guardianship means somebody needs assistance with all aspects of their lives. A limited guardianship is when we only need help with certain circumstances. For example, somebody cannot make medical decisions, but can retain the right to drive, retain the vote, retain the right to get married, and so on and so forth. That's something that we're going to need doctors to substantiate and perhaps a court-appointed attorney, which we will get to a little bit later. We also have guardianship of the person only or guardianship of the person and property. So there's a big distinction here. Person only means that you can make somebody's personal decisions for them, where they go to school, where they live, what kind of job they're going to do, their medical decisions. But let's suppose that person does have a job and they make an income and you need to do banking for them. If you have guardianship of the person only, you're not going to be able to go walk into a bank and handle that check and put it into a bank and deposit it. You need a guardianship of the person and property. If you have a guardianship of the person only, the bank is going to look at your letters of guardianship and say, nope, we can't do anything. And then you're going to call your county surrogate and they're going to tell you you have to go back to court to get a guardianship of the person and property. So what do you do? First things first, I always tell people when they call up, get a lawyer. But we cannot make you get a lawyer. Everybody is free to proceed what they call pro se without a lawyer. If you choose not to get a lawyer, there is a very detailed packet available on njcourts.gov. In the slideshow, I have links to both packets. The first one is for guardianship of the person and property. The other is for guardianship of the person only. My slideshow should be available after the seminar so that you can click on the links. But keep in mind, the rules of court are constantly changing. Right now, we had a major change to the court rules last spring, and these packets have not yet been updated to reflect the changes in the rules. So if you download this packet without the additional forms that are also available, you will send it to your surrogate's court and they will reject it because it does not comply with the rules. The documents required to file for guardianship, I've listed them here. I'm going to try to split my screen so I can go back and forth to the form so you can see them. Okay. Hopefully everybody can see this. This is the packet for how to apply for guardianship of the person and property. It's lengthy. It's about 35 pages. A lot of it is instructions. We're not going to go through everything in detail. I just want to show you briefly what the forms look like. So if we scroll down to page 11, we have a case information statement. This is the first form you need to fill out. The forms are self-explanatory. My first rule of guidance, anywhere that looks like you can fill it in, fill it in. Don't leave anything blank, because if we see blanks, unfortunately, the surrogate's court is going to have to reject the pleading. The case information statement is just asking for background pedigree information about the alleged incapacitated, the plaintiff who wants to be guardian, and any other family members. Okay, your next form is called the verified complaint. And this really is where we're going to ask for information about your child who you want to have declared incapacitated. Again, anywhere that you can fill in, it's your obligation to fill in. And keep in mind that the complaint, this is how we start a case. You're not complaining about anybody. I know the word verified complaint can be scary to people, but that's just how we start a case. And it's how the judge and the surrogate's court has the ability to learn about you, your family, and most importantly, the alleged incapacitated person. So take your time with the form, fill it out as best you can, and give us as much information as you can. The more information, the better. Okay, so the complaint keeps going. And then you'll see on the very bottom, there are some signature lines. You have to make sure you sign everywhere that it says signature. And if you had any specific questions about the forms, you would call your county surrogate in the county that you live, actually where the alleged incapacitated lives. Your next form is the certification of assets. That pertains to the assets belonging to the alleged incapacitated. So let's say mom and dad have a bank account with $100,000 and Billy Bob is going to be declared incapacitated. We are only concerned about Billy Bob's accounts, not what mom and dad have in the bank. If he has nothing, you will click the boxes that he does not have any assets. But if he has, say, $1,000 in Chase Manhattan Bank, you're going to reflect that there's $1,000, just so that the court is aware what the assets are. Now, the next form is your meat and potatoes form. I'm going to go back to my slideshow so I can iron out some details. Okay, your doctor's exams. This is where the rules kind of split. So depending on whether or not your child is eligible for and or receiving services from the Division of Developmental Disabilities will determine what you do here. So we're going to start with a child who is eligible for and or receiving services from the DDD. You're going to need one doctor to examine your child within 6 months of the date that you filed the complaint. You have to use the form that I had just shown you. And another form of proof in this instance can be your child's IEP from the school district or another doctor or a certification from somebody from the DGD, and there's a few other options that's explained in the packet. If you're going to be submitting the IEP, you need to submit the entire IEP, not just the first signature page, not the first 2 pages, the entire packet, so that we can look at it as a window into your child's life. Okay. A letter from a doctor is not enough. I get a lot of phone calls from parents saying, oh, I have a letter from the doctor saying my child is autistic. That unfortunately is not good enough. The rules of court require specific language in the doctor's certifications. So we do need to require that the certification forms be utilized. And keep in mind that this is a way for us to get to know your child. So it's not enough for the doctor to say that the child is autistic. We need to know what specifically about your autistic child makes him unable and unfit to manage himself and his affairs. Is he unable to cook a meal for himself? Is he unable to administer his own medications? What specifically about him? Okay, now we're going to talk about a child who is not eligible for services from the DDD. The instructions in the packet do not apply. We're going to need 2 doctors or 1 doctor and 1 psychologist to examine your child. We need to do that within 30 days of the date that you file the complaint. The rules of court are very, very particular about that. And I'll explain the reason for that is because when we're dealing with somebody with a developmental disability, that's a static condition. It's not typically going to get better. But let's talk about maybe somebody with who was in a car accident and is in a coma. That is a fluid condition. It can get better. It can get worse. But we do require the doctor's exam to be within 30 days so that it was a recent exam and the condition doesn't usually change that quickly. Both doctors in this instance are going to need to use that form that I showed you previously. Okay, and then all of the forms in the packet after this Form D, we have a cover page for the IEP if you're going to use it, certification and supportive guardianship if you're going to have somebody from the DDD or another appropriate person fill this out. You can use those forms, but anything after this form is not going to be able to be utilized because those forms have all changed to reflect some new background screening requirements that we have instituted as of, I believe it was May 15th of 2022 for proposed guardians. I'll get into that a little bit later also. Okay, so now that you've got all of your forms together, where do you go? How do you file? What do you do? Again, don't stress. You're filing everything in your county surrogates court. You can call up, get the address. Everything for us is mailed in or hand delivered, FedExed. We do not use e-filing. You cannot file through email. Now keep in mind, even though you're filing in the surrogates court, it gets a little tricky because the surrogate does not actually decide the case. We are the deputy clerk of the Superior Court Chancery Division probate part. So we accept the filings and we review all the cases, but a Superior Court judge actually adjudicates the case. So when the case is docketed, we will assign the case to the appropriate Superior Court judge. You have to check with your surrogates court regarding particulars on how many copies, specific rules for filing. Every county is different. I bet Essex County does it different than us. I know we require 2 copies of everything plus the original, a large self-addressed stamped envelope because we're going to mail you a bunch of stuff back. You're going to get 1 whole copy back along with some manuals that you have to read. And then there's a $200 filing fee.
So April, Essex is the same as Bergen.
Oh, fabulous. I know some counties only require 1 copy, and if you're requiring copies, it is full copies of everything. I don't need the instructions, but if you're giving me an IEP that's 40 pages, I need 3 full 40-page copies. All right, so when can you file? You'll have to check with your county surrogate. There's no hard and fast rule. Again, Essex will pipe in. In Bergen, we will accept the filing up to 60 days before the child turns 18. However, we cannot have a court date until after the child turns 18 because minors by law do not have capacity, so you cannot adjudicate somebody incapacitated before they turn 18. What does Essex do?
So we pretty much follow the same guidelines given the requirements, the 60-day requirements. So we play it close to the vest, just like Bergen.
Fantastic. All right, now you're excited. You got a court date. The hard part is over. Oh, not so fast. Not yet. There's a lot of legwork that's left. So we're going to go through those. And again, every county is different, but these are statewide requirements. So we will docket your case if everything's in order, and we are going to sign an order fixing hearing date. That will give you your court date, the judge, and it's going to give you a lot of instructions. So I always tell people, please read your order fixing hearing date. It is your Bible. It tells you what to do. If you don't read it, you're not going to make it to your court date. We're just going to have to keep adjourning your court date. Pay particular attention to the requirements for service of process. That means we have to send copies of all of the papers to next of kin of the alleged incapacitated, and also the alleged incapacitated has to be handed the papers, whether or not he or she can understand them. So even if Billy Bob is in a hospital in a coma, we still have to hand him the papers and read to him a notice of hearing. That's required under the rules. Okay. Also, the order fixing hearing date will include background screening requirements. I'm not going to go into detail too much here, but most proposed guardians in New Jersey are subject to mandatory background screening, which involves oftentimes fingerprinting and or a judgment search to determine whether or not there are judgments against him or her. Parents are presumptively exempt from that requirement, but if that parent has a criminal background, at least here in Bergen, we're going to require fingerprinting. And I'm going to pull up that form so you can see it. This is called the Certification of Criminal and Civil Judgment History. You will need to fill out this form and send it in with the packet, all the other stuff that I showed you before. It's asking whether or not you were ever convicted of a crime and if you have any civil judgments against you. That would mean, if American Express sued you because you didn't pay your bill, that's a civil judgment. Okay, so you have to complete your background screening. The order fixing hearing date will appoint a court-appointed attorney. We'll discuss that later. The court is not going to remind you to complete these above steps, so stay on top of them. And then you will have your hearing date, which at least in Bergen County is about 6 weeks following the date of filing. Every county is different. Every county has a different docket. So just because something happens here in Bergen does not mean it's going to happen the same way in Essex County. And then there's some post-judgment requirements. You're going to have to fill out a bunch of forms, potentially get bonded, and guardians are required to file annual reports. So if you become your son's guardian, that does not mean you're done. It means that every year you're going to need to update us as to how he's doing personally, his well-being, and financially. All right, so I get this question a lot. Why do I have to do this? That's my kid. I've been his parent my whole life. The best thing I can explain is, what if somebody tried to file for guardianship of you? You don't get along with your brother and sister and they think you need a guardian. So they would go to court and, you know what? My brother needs a guardian. Don't you want the opportunity to come back and say, no, I don't need a guardian. I can handle myself in my own affairs. The law protects the alleged incapacitated person. That's why we have all these requirements. Background screening, the court-appointed attorney. That's why we have to serve the alleged incapacitated person with the papers so that he or she can see them and say, oh my goodness, this is not right. What do I do? So now he can come out and say, I do not need a guardian. I object to this. Bond requirements. This is something, let's suppose Billy Bob, had a motor vehicle accident and came into $600,000 when he was 2 years old. The guardians are not going to have unfettered access to that $600,000. The court is generally going to require a bond to make sure that the guardians do not spend that money inappropriately. And then the annual reporting requirements that we discussed before.
April, before you move on, could you just explain to the listeners what a bond is?
Yes. Okay. So bond is like an insurance policy. It's not like you're not going to jail. It's not a bail bonds. It's insurance to make sure that you do not abscond with the money, so that the bond company would then be on the hook and then could come after you for money if you were to potentially philander it. If you were, say, bonded for $600,000, that does not mean you have to pay $600,000. There's an annual premium, just like you pay for your car insurance or your health insurance, and that is based on the value of the bond. And we generally bond on liquid assets. So if somebody owns a piece of real estate, we're not going to bond on that. But if they have a bank account with $500,000, we'll generally then require a $500,000 bond. All right, finally, some do's and don'ts. As I said before, read your order fixing hearing date. Get a lawyer, particularly if you have complicated issues. Maybe a special needs trust is required, or you're not able to complete service on a parent who disappeared 20 years ago. Ask questions of your surrogates court. Be prepared, and most importantly, be kind to court personnel. We deal with public all day long, and we are more than happy to help people out. But as we all know, being nice goes a long way, and we are always more than willing to bend over backwards if somebody's being kind to us. Some don'ts. Don't forget to get fingerprinted, and also do not give court personnel a hard time about getting fingerprinted. We do not make the rules. It is required. If you don't want to get fingerprinted, that's your prerogative, but the judge is never going to appoint you as guardian. Don't assume you did everything right. Don't get upset if we tell you you did something wrong. We are here to help you. We are not your enemy. But also, this is a big thing. Don't assume that because your friend became guardian for his or her son in 2004, the rules are exactly the same. The rules are fluid. They're constantly changing. We have different judges, different counties, different rules, different times. You know, things are just always different. So understand that. Okay, and that is all I have for now.
So thank you, April. And what I like to do is let everybody know your background real quickly. So April is a special deputy surrogate in Bergen County. I'd like to thank surrogate Michael Dressler for allowing her to participate in this day, this evening, because we love collaborating with other counties. There are 21 surrogates throughout the state of New Jersey, and we all work together to educate not just the constituents in our county, but throughout the state of New Jersey. So thank you for that. April, unfortunately, was a graduate of Seton Hall, not Rutgers, but I'll let that pass. She served as a law clerk for the Honorable Peter Doan. I might be saying that wrong. He was a Bergen County Superior Court Chancery Division. He's now retired. He served from 2004 to 2005. She was in private practice for 13 years in Passaic County, during which time she served as a court-appointed counsel, guardian ad litem, and guardian in various incapacitated matters. In 2018, she decided to leave private practice, and hence that's why she's here today, because she's now at the Bergen County Surrogates Court. And so I thank you for assisting us today. We're going to have a question and answer. You can ask her questions later. And the other person who I believe is now ready for us is Ms. Thomasina Thornton, who is a sole practitioner with a practice located in Roseland, New Jersey, and New York. Her primary concentration is in this area, the area of trust and estate, where she does estate planning, wealth transfer, asset protection, estate tax planning. She also handles estate administration and guardianships. She has served, she does a various range of services, which include preparation of wills, trust, power of attorneys, advanced directives, and charitable planning. She also assists families needing guardianships for their loved ones that are aging. And what she's going to talk about today, as April ran down the process, one of the things that she indicated is that a court-appointed attorney will be provided to the alleged incapacitated person. So she is going to discuss that for everyone out there, so you can understand exactly what the responsibilities of a court-appointed attorney is.
Thank you, Devereaux, and thank you for having me here today. Hopefully everyone is hearing me well. Thumbs up. Thumbs up. Okay, great. So again, my name is Tommy Thornton. I'm a trust and estates attorney. So what I wanted to speak to you all today was in regards to serving as a court-appointed attorney. So many times, depending on the counties, counties will find attorneys who will be appointed to represent the alleged incapacitated person. And so I have served that role in various counties. I also, April did a wonderful job. It was extremely comprehensive. So I'm going to try to make a point of not repeating anything that she has said. But what I'd like to just do is to share a screen as we go along, and I'll just talk about what my role is and some of the experiences that I have had in regards to serving as a court-appointed attorney. I'm going to, just for lack of time, when I say court-appointed attorney, I'm just going to start using the acronym CAA. So you'll know that I'm referring to the court-appointed attorney. Also, I'll use the acronym AIP, the alleged incapacitated person, because a person, until a judge has adjudicated that individual to be incapacitated, they are to be alleged as. So that said, if we could move on to the next slide. Okay. One thing that April said, and I want to make sure that I emphasize this, serving as a court-appointed attorney means that I am representing the alleged AIP. Period, hands down. I don't represent the parents. I don't represent any interested parties. I do not represent even the court. I represent the person who there's an application being made to have that person declared incapacitated. So in my duties, my allegiance is always going to be to the AIP. And I'm so many times I have to just make that very clear. So, in serving as an CAA, I want to always listen to what the alleged incapacitated person is putting forward. Now, the next slide, I do talk about, because this is not necessarily the seminar to get into all of the different nuances of the process, but on occasion, you may have a CAA that runs into a conflict with their AIP, meaning that they feel that for whatever reason, they're not able to advocate in that person's best interest, or that individual AIP has a matter that needs immediate guidance from the court. They need someone who needs to be able to have the ability to be able to make legal and financial decisions for them immediately. When that happens, there can be an application put forward to have the court-appointed attorney replaced by what we call a guardian ad litem. And I'll just use the acronym GAL. That guardian ad litem may be appointed, again, before the entry of any judgment, where there are special circumstances that would require a judge to move in that vein. The difference between the CAA and the GAL is that the GAL has a duty to evaluate the best interest of the alleged incapacitated person and present that information to the court. So he or she is not always just adhering to the wishes of the AIP. They're making more so a judgment call that's going to be in the best interest, again, of the alleged incapacitated person. Okay, next slide. So what happens as a CAA before I meet my client? Generally, I am going to receive a packet of information from the surrogates court. That information will include the complaint, and that's the complaint that is going to be prepared by the petitioner. They are going to review any orders, other pleadings, such as certifications, perhaps from interested parties, certifications from the proposed guardians. I would want to read all of the doctor's reports. Doctor's reports can be submitted by the primary care physician, as well as there's some type of alleged mental incapacitation, inability to be able to make decisions. Then I'm going to want to read the reports of a psychologist or a psychiatrist. I will also want to review any certification of assets. So again, if the AIP has any assets that are in his or her name, I want to know what those assets are. If there's also already some type of a special needs trust in place, that would be a document that I would want to review and try to make an assessment of. And taking all of those things into consideration, what I generally like to do is to read all of that information before I meet with my client, so that I have a good understanding of the background of that individual. Next slide. Okay. Now, you know, the last 2 years have been really precarious for all of us in dealing with COVID. And I think as CAAs, we found ourselves trying to navigate in this COVID era. So ordinarily, what would have customarily happened is I would have received information on my client. I would call the petitioner or maybe their attorney and set up an appointment to physically go and see them, whether I'm seeing them at their home, which is generally because that's usually where people are most comfortable. Also, I would like to see people in their homes, because this gives me an opportunity to see what the environment looks like, to see if there are other family members that are there, to take a look around. And sometimes I almost feel like a social worker, you know, to some degree, but I want to take a look around and see what are their sleeping quarters looking like. If it's let's say an AIP that has an inability or problem with mobility, and maybe they're in a wheelchair, to make sure that the home is wheelchair accessible. So again, we're really wanting to see what the lifestyle looks like for that AIP. And you can imagine with COVID, that became quite challenging. So for that time period where we were really not going into people's homes, we were trying to become creative. And so I did have one matter where we did everything by Zoom. And so the parent was very cooperative, kind of walked around. I met everyone, but it was literally doing everything via Zoom. And quite frankly, it worked out. I got a sense of what the family dynamic looked like, and as well as the home, and talked to all the parties via Zoom. So that actually worked out. But the customary way had been to personally meet with clients. Now, I don't know what all attorneys are doing, but based on where we are at this given time, I am going back to my old policy of personally visiting with my AIP. And so I do the same thing, walking around, observing, and then reporting the condition of those findings back to the court. Also, so again, personally interviewing the AIP. I'm also going to want to interview any caregiver or other persons that are familiar with the AIP's physical and mental state. So again, if I get to the house and mom's there or siblings are there, that's going to give me a good opportunity to speak to other individuals that live in the home, and particularly if mom and dad or mom would be the proposed guardian, to have an opportunity to speak with that person directly as well. Now, let me go back a little bit. One of the little, just as I'm thinking about, as I'm walking through and talking to folks, I always, if that individual is able to communicate on his or her own accord, I also like to, if I can gather a comfort level with them, ask if they wouldn't mind taking a few minutes to maybe spend alone with me. So if we're all in the living room or at the dining room table, maybe asking mom or dad to step away, because I want them to feel comfortable that they can convey information to me that they would have some concerns about. Also, again, depending on the individual's level of comprehension, clearly trying to explain to them what this process is, trying to remove whatever fears that they may have or apprehensions that they may have. And again, at this point, just trying to gather or trying to get their confidence so that they will be as candid and share information with me so that I can make a true assessment as to, number one, that person's inabilities or abilities, and as well as to make an assessment as to the proposed guardian, whether they are the appropriate person or persons to serve in that role. Okay.
Tommy, can I just add something to that?
Certainly.
That's a very important piece because as Tommy indicated, her role is to be the advocate, the zealot advocate for the alleged incapacitated person. And part of that, like any other client that she has a legal, ethical obligation, I should say, to communicate with them. And there's a privacy issue as well. So if they can communicate with her, because sometimes the AIP may not be able to communicate, but it's her duty to make that effort and treat them like any other client, whether they had a disability or not. And so parents, loved ones, don't be offended if your court-appointed attorney asks you to do that, because they have an ethical obligation to speak to their client, and wherever their client is, they have to, like I said, be a zealot advocate for them. So that's very important that Tommy said that, because that is her ethical obligation to make sure she communicates with her client, and when possible, ensure that there's privacy. Thank you, Tommy.
Mm-hmm. Thank you. Absolutely. Absolutely. All right. Next slide, please. So this is where, and I do court-appointed attorney CAAs in regards to young people who are reaching the age of 18, as well as individuals who are adults who may have had are starting to have some issues and challenges in regards to being able to advocate for themselves. But in terms of not just interviewing the AIP, but also interviewing the proposed guardians, there are going to be questions that I'm going to ask of those proposed guardians. Some of a quick question that I'll always ask is, why do you want to serve in this role? And sometimes people are taken aback because they would say, well, you shouldn't, why wouldn't I? I do this? But that's going to be a question that you should be prepared for. A CAA asking, why is it that you want to serve in this role? What are your intentions in regards to the future care of the AIP? Have you considered a care plan? If you have one in place, I would like to take a look at that. Getting a little bit of background information on the guardian as well, particularly if there are financial assets involved. So I think April made a good point about on occasion we will find children who maybe due to some birth defect or something that was done, they have settlements, and now there is a significant amount of money, and those monies may need to be invested properly. And consequently, again, just questioning that guardian to make sure that they are able to handle those financial assets on behalf of the AIP. Next slide, please. I think April also mentioned that on occasion there are background screening that are required. So again, I'm going to want to review that information as well to determine if there is anything in a person's background that may either disqualify them or may be questionable in regards to them serving as a guardian. Next slide.
Tommy, can you tell everybody the exceptions to the background based on the new requirements as of May 2021?
Can you share that? Do you have a slide on it?
So I don't have a slide, but just to let everybody know, as of May 2021, there are a few exceptions. The one that are more relevant to anyone listening right now would be parents of the alleged incapacitated person and their spouses. There are a couple of other ones that really don't relate to the audience that we're talking about. But I want to be clear that the judge, and as April said, not the surrogate court judge, but the Superior Court judge does have discretion to ask for a background check, even if you are in that that class of exempt persons.
And I would think, DeVero, that there would be a greater probability of that happening if there were assets that were substantial.
That's possible, but the judge looks at all the facts and circumstances. So, for instance, as April talked about, the laws have changed. So if mom or dad was the guardian years ago and they're getting older and they cannot be that person now, and let's say a sibling wants to do it, that's a reason to do a background check. Or a dad who wasn't involved in the past now wants to be involved. The judge may wonder, why now? What I need to know a little bit more of their background. So it's for the exception for the parent, to be more precise, as opposed to a brother or sister. So it's the judge's discretion. But each person is going to have to do a certification on their criminal and civil background, which is totally different than the actual background check. You're just certifying to the fact that there are no civil or criminal issues that the court should be aware of. That's totally different than what you're talking about in the background check, with whether or not there are going to be fingerprints required.
Right. Okay, thank you. Okay, so we're at the next slide now. So again, the CAA has the obligation to identify any assets. We're talking bank accounts, brokerage accounts, if there's a special needs trust in place. For this group's purpose, I am kind of making an assumption here, and that's why I put the note that most of these AIPs are going to have limited assets or no assets other than their Social Security benefits, or perhaps their DDD benefits, the Division of Developmental Disabilities benefits. Also, the CAA, if there are Social Security benefits, that CAA should indicate who is the Social Security representative payee, and note that for the file, for the report. Next screen. Again, for this particular group, because we're focusing on children who are close to or have reached the age of 18, for the most part, those individuals do not have these types of advanced plannings, but recognizing that if something were to happen, if they do have a power of attorney in place, a last will and testament, a living trust or a living will, that should be a document that should be made available to the CAA to review that and to give an overall assessment of those documents for the court. Just as a side note, strongly encourage people to have a power of attorney, because if an individual, before they are declared to be incapacitated, if you have a general durable power of attorney in place, many times that document will be adequate and will alleviate the need to have the guardianship process. So all good documents for anyone over the age of 18 to have. So
Tommy, it's approximately, it's about 6:49. So how much more time do you need? Because I want to give everybody, we have a few questions that I want to have you guys respond to.
I can get this done in less than 5 minutes. We'll keep.
Okay.
Okay. So you keep me honest. Okay. Okay. Next slide, please. So as the court appointed attorney, I'm going to draft my report. I'm going to file it. That report is going to be submitted to all parties. So the petitioner will receive a copy, the court, as well as my client. Well, everyone will receive a copy of that report. Next page, please. Okay. Now, the big question on your mind may be, well, if I'm doing all of this, our court-appointed attorneys, are they financially compensated? Okay. So the short answer is yes. I will tell you that depending on certain judges, and probably every county is different, but there are certain judges who will certainly make an effort to, if there are no funds other than maybe the Social Security benefits, to ask a attorney to take on the matter as a pro bono case. So that would mean that there is no compensation to that attorney. And you can just see under the rules, if there will be compensation, then it's done under Rule 4:48-5. Okay. Next slide. So the next thing, so after that report has been submitted, the CAA will appear at the hearing. Now, again, what we have been doing lately with COVID, under the COVID era, is that we have been making our hearings via Zoom. So in that particular case, the CAA is appearing Zoom, the court's appearing. The CAA has the right to waive their clients, the AIP's right to be at the hearing. That is done under Court Rule 4:48-5C. The court-appointed attorney can also waive the right of the physician to appear and just rely upon the written affidavit or certification of the physician. So again, alleviating the need for them to have to appear at the court hearing.
Quick question, Tommy. Is it the court-appointed attorney waiving it or the judge waiving it?
The court-appointed attorney can waive, number one, their client appearing, and the court-appointed attorney can waive the need for the physician to appear. But we're placing it on the record. The judge can always say, if there's a dispute, the judge can always say we need further testimony. So I will say, if it's a very straightforward case, then I will waive the right for the physician to be there. But if it's questionable, some of the information is inconsistent, things that are in the report are inconsistent with the findings of my observations, and I need further clarification and want the judge to actually hear testimony, then in that particular case, I obviously wouldn't raise it. Or if the judge felt that the report was inconsistent with what the physician's report indicated, then at that point the judge can require that there be testimony. But I will tell you, in my 20 years, I've maybe once, it's very rare, when the CAA waives it, I've never seen the judge really come in, maybe once. Okay. Okay, I think that brings us to, oh, let's go. Okay, so let me go back, please. What screen are we on? So if you would proceed. Oh, thank you. I think you've already advanced to the next slide. So after the report has been submitted, there's a court hearing. The CAA will make an oral summary of his or her findings, as well as an oral conclusion that is placed on the record. If the AIP is there and is able, they can give testimony. There will be testimony taken from the from the proposed guardian. So there are going to be questions such as giving a background as to who that individual is. If there are questions that need to be clarified, giving, particularly if the CAA has maybe some doubts or questions as to whether that is the appropriate person to serve. For the most part, I haven't had that happen when parents are wanting to serve on behalf of their children. That generally happens when you've got mom and dad, and you may have various siblings who want to be a guardian or are protesting having another sibling serve in that capacity. After all of the testimony has been taken, at that point, the judge will generally make a ruling as to whether that individual will be declared incapacitated. The judge will indicate whether it will be a limited guardianship or full guardianship. There are other types of matters also, a conservatorship. We don't necessarily have the time to go into all of those things, but the judge will make that ruling, and then the judge will then prepare a judgment of incapacity. If the judge finds that person to be incapacitated, will prepare a judgment of incapacity. The judge will also at that time determine whether there will be any attorney's fees that will also be memorialized in the judgment. And then from there, and you all may get back. I'm not sure, Deborah, will you all talk about the next process, which is then if the person is found to be incapacitated, then there are further steps that they need to take in regards to the surrogates court to secure their letters of guardianship. I suspect.
We could talk about that real quickly, but the other thing is, besides declaring the person incapacitated, judge is also going to determine who should be the guardian of the person as well. So it's a two-pronged process. The judge will make that determination. And so as Tommy said, after that is done and the judge makes his or her determination, if the person is declared incapacitated and guardian is appointed, then that individual will have to come to surrogates court. I will actually let April respond to that. But before I do that, let me get a couple of questions. One for you. Can a guardian be changed?
Okay, yes. So as I said, I am a court-appointed attorney. And AIP has the right to hire their own attorney as well. So, so to answer that question, yes, an AIP can hire their own attorney. The court can change a court-appointed attorney if there is a reason for a conflict, if there's some form of a conflict. And then also the guardian ad litem issue that I brought out earlier, that person can sometimes come in and take the role of the court-appointed attorney as well.
Right, and also just to let I think it's just questions from George Stillwell. Also to let George know there are times where another guardian needs to be appointed. Let's say mom and dad was appointed the guardian for their child, even though they may be adult, it's still their child, and they're aging and they can no longer do it. Then there's a couple of ways to do it. Like a brother or sister may want to do it so they can become a co-guardian. A lot of judges don't like co-guardians because they don't like to see family members arguing. But a guardian could be changed because, like Tommy was saying, somebody may decide that it's in the best interest of the individual to have another guardian for whatever reason. There might be a complaint or whatever, but that has to go to court to determine whether another guardian should be appointed or co-guardian should be appointed. But that definitely can happen. Also, in that vein, if the alleged incapacitated person, and what we're talking about disabilities is probably not going to happen, but let's say by chance that individual gains capacity, they can go back to the court and petition the court not to have a guardian and to declare them with capacity, because this goes towards Cheryl Clark's question: is the procedure the same if the child is over 18? I mean, this is only for persons over 18, but the procedure is saying even if this doesn't involve a person with developmental disabilities. If you have a senior who's has some senility issues, these procedures, what April and Tommy talked about, are the same. And I'm going to turn it over to April to talk about what the, because she did mention it and earlier in her presentation, what's after the judgment has been rendered, what's the guardian's responsibility?
Right. So we have to do what they call qualify and accept the guardianship. So that is really filling out some forms. I don't know how Essex is handling it. Bergen right now, pre-COVID, we required you to come in before one of our probate clerks to qualify as guardian. Now I'm sending all the qualification papers to the counsel for the plaintiff and or the guardian if they're not represented by counsel, and they can bring it to a notary and sign the forms that way. Send it back to us. If there's a bond, we have to get the bond forms filled out, and then once we have all of that, we will issue letters of guardianship. So if all systems go, it happens relatively quickly. The judgment actually says that you have to qualify within 30 days. If you don't qualify within 30 days, you're going to get a nice little love letter from the court saying you didn't qualify within the time required. So as soon as you can get that done, you got to get it done. If you do not qualify, you will not get your letters of guardianship. I mean, we've had people, particularly during the pandemic, who never qualified. And then they call up, why don't I have letters of guardianship? You can't get them until you fill out the qualification papers.
I see the wonderful surrogate from Essex County. So let me It's 7 o'clock. Before we depart, I definitely want him to come on and say a couple of things. And if there's any questions, he's going to take over the Q&A.
Thank you, DeVero. Wanted to say thank you for those who decided to participate in this tremendous conversation. Thank you, Tommy, and thank you, April, for loaning us your expertise and also educating not only the public but myself, as a surrogate, about the affairs that are happening within courts throughout the state of New Jersey. Uh, First, let me say welcome to this conversation of looking into the future, a Developmental Disability Awareness Month seminar. It's brought to you by Essex County Surrogates Court. We're working in collaboration with the Bergen County Surrogates Court, and I'd like to thank also Mike Dressler for loaning us April and her expertise in this very important subject matter. My name is Alex McKinney. I currently serve as the Essex County Surrogate. And Surrogates Court is responsible for validating wills, appointing administrators for those who die without wills, and reviewing and assisting the documentation surrounding adoption and adult guardianship. The office, as DeVero and April stated so eloquently, touches the lives of every individual in respective counties we touch, Essex County. And we want to ensure that this process that you undertake, every form you fill out, every question you ask, and equip approachable and accurate information. I also wanted to share as well is that the surrogates court as it relates to disabilities. Disabilities touch the lives of thousands of people throughout the state of New Jersey. In Essex County alone, we have over 90,000 residents who are been diagnosed with disabilities, and 10% of the state's population has been diagnosed with disabilities. So this is something that's very important to not only learn the tools, but also to get accurate information about what to do next. And so this conversation is about raising awareness. It's also about ensuring that as these sort of questions are coming up, you are able to ask and answer questions from attorneys, who are loaning their time and lending their expertise at no cost. Thank you, Tommy. And also you're able to get years of expertise from April and DeVero about what to do next in this very, very important procedure. But this is your time to ask questions. I'm going to ask a few questions that was asked prior to this evening. Anyone can just jump in and answer these questions.
Surrogate Kenny, before you ask the questions, I actually realized as Tommy was doing her presentation, she answered the questions.
Yeah.
She answered. So if we can, I actually have some different questions that I think will be useful if you don't mind.
Sure, go ahead.
So can a guardianship be transferred to another state or out of the country?
Yes, it can. As far as in-state, we tend to keep guardianship in the county that we started in. So if you lived in Bergen County and then moved down to Ocean, we're not going to transfer typically between counties. But if you move to Pennsylvania, we are going to require transfer of the guardianship. And it's actually multiple actions. I call it a game of ping pong. We start here. You have to file a complaint to transfer the guardianship here. The judge will enter a provisional order transferring, and then you have to take that order to the incoming state and file a similar action there. So you would need to, speak to the surrogate or our counterpart in that state, figure out what the procedure is, and you kind of go back and forth between states.
So I have a question for Tommy. So what typically is the fee that a court-appointed attorney would receive? I know the judges have a discretion. So typically, and it doesn't have to be your specific, but typically your experience, what has the judge allowed a court-appointed attorney to receive in terms of fees?
Okay, that's a good question. There is what they call a reduced rate, and that rate generally ranges between $200 I've never seen over $300 an hour, right? So the court-appointed attorney is billing at an hourly rate. Now, assuming that you are let's say attorneys who have been practicing over 20 years, you may be billing at $400 an hour. So that means that if you accept that case, you in turn will accept that reduced rate that averages somewhere around $250 an hour.
And as you
Right.
said, there's many times that that an attorney may waive his fees, or the judge may require it to be waived because they realize the alleged incapacitated who become the potentially the incapacitated person doesn't have the funds to pay that.
Right, 100%. I have seen it go both ways, kind of, I guess, depending on the judge. But again, for the most part, if that person really has very little assets other than the governmental assistance that they're receiving, most judges are going to require that that attorney serve on a pro bono basis.
Right.
I'm sorry.
Go ahead.
I actually have a little comment there too. Let's suppose mom and dad are filing for guardianship. They hire their own attorney, and then they're seeking a pro bono attorney for the alleged incapacitated. At least in Bergen County, we're not typically going to then award a pro bono attorney because mom and dad were able to go out and hire their own. So at that point, then they can generally foot the bill for the attorney for the court appointed.
Yeah, that's a good. I agree. Good point. And I think it's a case by case, judge by judge, because I have seen that happen where certain judges are allowing mom and dad to hire an attorney to represent them, but they're wanting the CAA to serve on a pro bono basis. So depends on, I think, the judge that you have.
And if people call the court and ask us what the rate is, I am going to flat out tell you, I cannot tell you what the rate is going to be. Every case is different. In Bergen County, we actually have a set fee, which is $225 an hour for the court-appointed attorneys. But the judges do have discretion to go above that. I mean, if the case ends up like a divorce that's now morphed into a guardianship where we're arguing over custody, the judge may require additional fees associated with that.
I have a question. It's just a follow-up question regarding court-appointed attorneys. How diverse is the pool of court-appointed attorneys, and does diversity matter in this regards? How
diverse is the pool?
Yes,
I can answer that question. So each vicinage, which is, so in our terms, basically each county, I'll just keep it that simple. The judges will have a pool of attorneys that, and when I say the judges, the Superior Court, Chancery Court, probate judges make up the list of attorneys. And many of the judges, there was a surrogates and probate roundtable earlier today. Many of the judges try to make the bar look as though the actual vicinage looks, the actual county look. So they like to have diversity, but diversity, to be perfectly honest, may not happen because this is a specialized area that people get into. Tommy happens to be perfectly honest, Tommy happens to be one of the few African American women that does this work. So it's I know Judge Alpert in Essex and Judge Paganelli and Judge Kaprowski, they like to make sure that the bar looks like the community that it's serving.
Sure.
But that becomes an issue if the individuals that look like the community doesn't practice in this area.
Sure.
But there's quite capable individuals that can handle this work. And what the judges try to do when it comes to the court-appointed attorneys is they try to rotate the individuals because many times they may ask a court-appointed attorney to do this pro bono, and they understand that this is an attorney's livelihood, so they don't want to have one attorney do all the cases, so they try to rotate it amongst the attorneys. And the reason why we, as you know, Surrogate Kenny, do these types of things, and places like New Jersey, what we call NJ, ICO, and other institutions that do CLE, is to allow diversity in the bar to do things like this, because we do know many people are comfortable dealing with people who understand them, come from the communities they come from. So judges do an excellent job try to keep that in mind when they make up the list.
Thank you, Devero. Let me go to some of the substantive questions, and I think you answered the question, but I just want to revisit it again. What are some of the common mistakes you see when people make when they file for guardianship?
I think mostly it is not asking enough questions and assuming you're doing it right. So, you know, they pull the packet from the internet, which has not been updated, and it's a lot of work to fill out the forms. So people, you know, kind of don't do the best job filling it out. They send it in, they don't make copies, they don't follow our procedures, and then unfortunately we have to reject them. So I think that's your biggest mistake, is not asking the question ahead of time, because it's actually a lot more work for not only the parents but also the court to review papers constantly over and over. I appreciate it when people call me and find out how to do it. I'll send them all the new forms, and then I will actually let them email the forms to me that they filled out before they go ahead and make copies, so I can look at it and make sure everything is done right. Because otherwise they're mailing me papers, and then, oh, you need to fix Form D. They'll send me Form D. I have to reattach things for them, and it takes a lot of time. Sure. So always just ask questions. Don't make assumptions. You know, I actually just had a parent who unfortunately tried to go through this whole process, but his doctor's report only told us that the child had ADHD. Now, I'm not a doctor, but I do know that there are millions of Americans with ADHD. So we cannot declare somebody incapacitated based on that alone, you know, not giving us enough information. Right. You know, we don't know your kid. I said that before. So it's the more information you can give us, the better. It's not going to hurt. And I think also it's a little bit of pride. You know, we're parents and we want to do what's best for our kid. But don't get upset at the fact that we have to follow these procedures, because the rules are the same for everybody, whether or not we're talking about an 18-year-old or a 100-year-old who has $10 million to his or her name. We have to treat everybody the same. So, you know, maybe there's one bad guardian out there, but we have to protect the incapacitated person.
And Surrogate Kenny, let me provide everyone with the 2 point people in Essex. April is a point person there in Bergen. So we have 2 individuals that handle adult guardianship, and we'll try to post it in the chat area so people can have it. But we have Ms. Tara Wilson, just like April. She can answer any questions that you have to avoid those common mistakes. Her telephone number at the office is 973-621-4907. We also have another young lady there by the name of Ms. Rihanna Johnson. Her number is 973-621-4905. Just as April said, if you have any questions, feel free to contact any one of them, and they definitely will help you out. I know that other counties, you know, I see Mr. Raul Morales, who is the deputy surrogate, special deputy surrogate in Hudson. I'm sure he feels the same way as well. Give him a call and they will eliminate that. And if you can, Raul, if you can put your information in there, that'll help individuals who are trying to do adult guardianship in Hudson.
Raul, thank you for joining this conversation. We appreciate you and all the work that you're doing in Hudson County as well. So thank you for joining this conversation. April, do you have a ballpark figure of what the cost might look like?
I mean, generally it's your $200 filing fee.
Sure.
And then your court-appointed attorney fee, which as I said before, I can't really ballpark. If you hire your own attorney, that's separate and apart from a court-appointed attorney. So that's generally between the parents and the attorney. And then sometimes if you need experts, you need doctors. If you can't get your primary care physician, and particularly this, I think, is more relevant to the Alzheimer's or dementia population, where sometimes we need an expert and we're paying an expert to issue us a report. So sometimes there's costs associated with that as well. Also, if there's a guardian ad litem appointed, that guardian ad litem is generally paid as well.
Okay. Great.
And then there are, I mean, we're not going to get into this, but just guardians are entitled to commissions based on the value of the incapacitated person's estate. So if you're handling $1 million, the guardian will be able to take a statutory fee from that as well. But that's after, and that's generally not for 18-year-olds. So my kids are going to be living off me forever. So.
Thank you, April. Also want to remind everyone who's watching, please ask your questions, type your questions in the comment section. We would like to answer as many questions as you have to make sure that we are able to provide you as much information in this program, because again, this program is to service you, is to provide you enough information to arm yourself with some difficult and some emotional times. I want to go back to another question that someone asked. Does a child need to appear in court for the hearing?
Okay, so that would be a question for the CAA. The CAA can make that determination as to whether the child should be there. I have seen various packages put together where we'll see one doctor who says the person has the ability to appear, and then the other doctor says that the person is, unfit and unable to manage and should not appear. So when there's a contradiction, generally, I think the CAA has to kind of make a judgment call, as well as speaking to the AIP to ask them if they would like to be there, because they have every right to appear during that hearing. But is it a requirement? No. If the CAA determines that the AIP should not, then the CAA can waive that individual's right to appear based on the court rule 4:86 in that section.
Great. Thank you. I know we are bumping against, the hour. I know we're going over a little bit. I just wanted to share one more thing. And I have one more question I asked, but I just want to share one thing as well that Tommy mentioned regarding children and young people. For several years, I served in the school board and in the city of Newark, and the issue of guardianship and disabilities never came up. For the 3 years that I serviced the Newark Public School District, which happens to be the largest school district in the state of New Jersey. And so these sort of conversations, we felt, DeVero and myself, was critical and important to the communities that we do serve, who were sometimes devoid of information, but also the communities that are hit the hardest by either mixed diagnosis or by lack of information, lack of access. And so what you're doing tonight, April and Tommy, are helping us service populations that are traditionally either ignored, have lack of access, but need the information that's critically important to service this population. So I just want to thank you, up front about everything that you're offering, everything that you're doing. And that's why I also want to encourage people to ask questions. Hopefully we'll answer some not tonight. If we can't answer them, we'll answer them on our Facebook page. And also April and DeVero will make themselves available to answer the questions representing us, our respective courts, as well as Tommy as well. A few more questions.
Sorry. Yep. As well as Raul Morales.
I'm sorry, Rahul. I apologize, Rahul.
201-795-6378. His email address is, I think I got it. I don't have glasses on. I refuse to buy them. But rmorales@hcnj.us. So Hudson is represented here, so reach out to them as well.
Yeah, and also want to say the deputies and assistant deputies are the most important people in the courts. We come and go, but these people are the laborers and the ones that do the work. So make sure you reach out to them. It's not something you should take for granted. What are the differences between a parent and a guardian? I think that's a simple answer.
So you're always a parent. You have a baby and then you're a parent for life, but you are not automatically going to be their guardian. My children will not be, knock on wood, will never be declared incapacitated. So I will, once they turn 18, never be their guardian. I am their natural guardian as their parent until the day they turn 18. And then, somehow they're expected to figure out life from there. So, but a guardian can be anybody. It could be a parent, it could be a grandparent, sister, brother, an independent attorney. It could be a lot of other things.
Sure.
If I may just throw in one other little, and that's such a great point, April. I have done some seminars and on YouTube and my Facebook page, and I talk about the importance of having, once our kids reach the age of 18 and have no developmental issues or anything of that sort, one thing that you can get them as a graduation present is get a power of attorney for them. Because if something were to happen while they're away at school, or they're working someplace, living out of state, or whatever the circumstance could be, once they're over the age of 18, you no longer have legal authority to handle any of their legal or financial affairs. But if you were to have a power of attorney for them, if something were to happen, you would be able to advocate for them and hopefully avoid this process, because as much as it is important, it can be extremely daunting. So if you can avoid it, get a power of attorney in place, it's worth every dime of having that done. And that's a very relatively inexpensive process compared to the cost of a guardianship.
Thank you, Tommy. And to let everybody know, you can reach Thomasina Thornton if you have questions at 973-275-5476. Once again, that's 973-275-5476. It is approximately 7:22. We stayed a little longer because we had some technical difficulties. We got all those worked out. As the surrogate said, that you can call any of our offices, Bergen, Essex, Hudson, if the alleged incapacitated person jurisdiction is in Without County. And I would say that for all the surrogates in Essex, in New Jersey, all the surrogates in the 21 counties will be more than happy to help you out. You can just go to their website or Google it, and you can find that information, and they definitely will help you. So with that, I am going to close it out. As the surrogate said earlier, we definitely appreciated having April here, Tommy here, and we thank surrogate Dressler for allowing April to be here. Oh, he popped back up. See, this is a technical difficulty.
The creator was telling me to wrap it up. That's what the creator was telling me to do.
So we definitely enjoyed this. And I would say on behalf of everyone, just to let you know that we in Essex, I got to do one thing. I know we're going over, but I feel remiss if I don't do this. We in Essex love to do community outreach. You can call our office, and we can work with you to do that. But what I have to do is recognize the late James LaCourte, who was the surrogate of Union County. He had served 4 terms. Each term is 5 years for a surrogate, and he was in his 5th term. So he was in his 22nd year when he passed away this past December. I have to mention him because he was big on educating his community in Union, but each community throughout New Jersey, because he came on with us at least 3 to 4 times, right, surrogate, to webinars. He was an advocate of everything surrogate, and he wanted everyone in New Jersey to understand the process to make life easier. So Surrogate Kenny and I will continue to do community outreach, partner with other surrogates to in the spirit of surrogate James LaCourte. We would do this with the passion he brought to the table each and every day. So I just had to say that, and I'm done for the night.
Yeah, let me just jump in one more thing as well, and before you go, and before we wrap this conversation up, thank you, DeVero, for making that comment. When I started serving, he was, a person that our court and other courts throughout the state used to answer difficult questions, and so James LaCourte is a giant amongst many, and his loss will be missed. And just wanted to say thank you for the years of service that he provided to his residents, but also wanted to say one other thing, that the serving in the last 2 or 3 years, one thing about Surrogates Court, we don't believe in, territories. We believe in helping any and everyone wherever we are. So whether it's April, DeVero, or even Raul, who joined us this evening, and many surrogates, Bernita, Ms. Toledo, from out of Passaic County, and many others who have joined these sort of conversations regarding community outreach. Then not one have rejected this opportunity to educate the public, as well as provide constituents they may not serve, in their respective county, but to help us provide information that is critically important to the residents that we are entrusted to serve. Tommy, thank you. Every time you've asked, you showed up and you showed out. We appreciate you and the things that you do. And I'm sure if people wanted to reach you, they can reach you at what phone number?
That would, so my New Jersey number, 973-275-5476. Also 973-609-2099. So those will be the 2 New Jersey office numbers.
Thank you. I appreciate it, Ms. Thornton.
You're
and April, thank you very much for your service. And if people want to reach you, how can they reach you?
201-336-6700.
Great. Thank you very much. And DeVero, thank you very much. And also Tara Wilson, we have to, give recognize the young lady who provides, the service to our county and to our residents. And so thank you very much. And thank you everyone for joining this conversation. I would have a song to travel out on, but I'm not going to do that this evening. Thank you. God bless. And good night.
Call our office, Ms. Clark. We'll help you out.
Take care.
Good night, everyone.
Good night.
Good night, everyone.